Hi, everybody. I hope you're having a relaxing week and a good day so far. I just wanted to check in here a little early for a couple reasons. Make sure, one, that you can hear me all right. If you can put that into the questions tab in your little control panel there, just to let me know that I'm coming through loud and clear. And then, secondly, ask a couple questions to you guys. We're kind of debating here in the office. If you could participate in any Winter Olympic event, which one would you like to participate in? And also put in your guess for how many gold medals the U.S. has over the history of the Olympics. And it's more than you might think. So if you guys just put in the questions tab there, and then we'll start right at noon. So thanks for joining early, and talk to you all in a few minutes. Well, for those of you just recently joining, the question on the table here is if you could participate in any Olympic event, which event would it be? Personally, mine would be the long jump, the skiing long jump. And also, if you have any guesses about how many gold medals the U.S. has won in both Summer and Winter Olympics in the history of time, put them out there. Yep. And we'll start here in about 3 minutes. Also, no Googling. Don't Google the answers. How? Okay, so we got some great answers here. We got some curlers, some snowboarders, a couple biathlon people, some ice hockey fans. You would get along with Mike Rosen here. And no guesses so far have been pretty close or have been very close at all, but the total is 2004 gold medals since our first Olympics in 1896, and that's in Summer and Winter Olympics. We'll give one more minute, or actually it's noon, so we'll start. Thanks everybody for being here. My name is Matt. I really appreciate you joining us today, responding to my email, and being here. We've got a great webinar for you all with some great people that you'll recognize if you've been on any of our webinars in the past. So to start here, hold on. Okay, so these are some faces you might recognize. Today on our webinar, we have Michael Rosen, our co-founder, and Donna Thiel, our Chief Compliance Officer. We're very lucky to have both of them. They have a lot of knowledge between the two, and have really put their time in here to give you guys the best kind of information that'll help you grow in your roles and improve your organization. So we're glad to have them. A little bit about us. We're made with love here in Nashville, Tennessee. We're a software as a service company, and we help compliance officers, HR professionals, finance, and other folks kind of make their jobs easier with easy to use software. That's just a little bit about us. Also, for you guys, don't worry too much about taking notes. We are going to share the slides as well as a recording of the webinar this afternoon, probably around 2 Central, 3 Eastern. So be on the lookout for that. Please share it with whoever you think would find value in that. And yeah, we'll get started here. First, we want to know a little bit about you all. So I'm going to start a poll here. And just tell me which department you work for. Hopefully it's on there. If you do choose other, please let us know in the questions tab, because we're interested in who you all are, and we like to cater the information that we bring together to our audience. So please let us know if you do choose other, who you are, and be sure to include some stuff in the future. We'll give about 5 more seconds for everybody to answer here. Then we'll close and share so you guys can see who all is on the call. Wow, the compliance officers really showed out today. We're glad to have you all, and risk, HR, finance, and other. Thanks everybody for being here. I'm gonna pass it on over to Mike to start off on our first topic.
All right, Matt, thank you. Winter Olympics, they're my favorite. I'm an ice hockey player, ice hockey fan from the South, and actually we now have a Stanley Cup contending team, the Nashville Predators. Go root for us again this year, I hope. The image I'd like to lead with, or start with actually, before we get into the OIG and imposing fines, because that's such a fun topic, is imagine Daniel Levinson, the OIG. What would his probably favorite sport be? And I'm thinking it's the downhill luge. So imagine that as we go into OIG Authority to impose fines. So we thought we might find it helpful to show to you some statistics across the board that may surprise you, and they may not. The OIG for Health and Human Services is one of the largest in the federal government. It's actually one of the older ones too. And Daniel Levinson has led it for the last 10, 12, 15 years. He's been very proactive in this area, and I think he's made a really nice, forged a relationship with the HCCA association, if any of you are members of it, as we are, and he really relies heavily on the partnership between the two, which is a good thing. He has over 1,600 employees that are focused on nothing but fraud, waste, and abuse. That's a lot in the federal government. 80% of that budget that he has been given is focused on Medicare and Medicaid fraud. So that's where they're putting their stake in the ground, and that's why it affects all of us on this call. In just 2017, according to the report they issued to Congress, they collected back over $4 billion in some type of fraudulent or wasted funds. So it is a high return for their investment dollar, being about $14 to every one that they spend in their budget going after fraud. In 2007, the fraud, waste, and abuse returned about 5 to 1. So this is a good business that the government is in. They're actually collecting back money that should have been either never been paid or was paid for wrong reasons. They did conclude about almost $50 million in civil monetary penalties, and we'll go into that in a little bit more soon. So let's talk about their authority, right? So the authority that the OIG has been granted is by several different statutes. One that might surprise you the most is the False Claims Act. Now, the False Claims Act actually was passed in the late 1800s. I'm a history buff. Before I went on to law school, I studied American constitutional history, and I found it interesting that the False Claims Act actually started then, and the reason was, even back in those days, people were finding ways to take advantage of the government. And this is when they were selling munitions to the government to help fund the Civil War. And people took advantage, shockingly, of the government. And so the False Claims Act was passed. Now, fast forward to today, since 1976, when the OIG was established at the Health and Human Services to fight fraud, waste, and abuse, the False Claims Act, as we're going to talk today, has to do with the typical types of false claims. Those are related to billing for services that were not rendered, or when an individual company was billing, yet the individual or entity was excluded, falsifying records, submitting claims that are unnecessary, and even upcoding. So we all know the False Claims Act, and there's something that came out, all puns intended. It's a brand new memo. It was actually issued by a gentleman by the last name Brand. This is a quote, a bunch of legalese, but the bottom is really what's important. This is brand new. It just came out about a month or so ago, and what it basically states is that the Department of Justice, which of course is tied to any of the enforcement cases that the OIG chooses to go after in the false claims area, the Brand memo makes it clear that the Department of Justice cannot use OIG guidance that's been issued as a basis for prosecution if you don't follow the guidance. So what does that really mean? What it seems to mean is that OIG guidance is there to do just that, guide you, provide you a roadmap, and we're going to talk about things that they have issued. But if you don't follow it, in and of itself, it is not grounds for the Department of Justice to go after your organization. It is, however, issued as just that, guidance for you to do your best and to learn best practice to follow. The Department of Justice will not now have a basis to come forward and say, well, you didn't follow a guidance, and therefore we're seeking a prosecution against you. Don't use that as your defense. Just use that as an understanding of how the DOJ and OIG will at least work together going forward. So the OIG has several other authority to impose fines in addition to the False Claims Act, and those would be under Stark and anti-kickback. We're not going to go into a lot of detail, but for those of you who are in the compliance area, you're well aware that if Stark applies to your organization, illegal incentives for referral, primarily physicians, are prohibited, and anti-kickback, any type of referral or any type of reduced rates in rent and those kinds of things can be seen as paying to play and not favored at all by the OIG or Department of Justice. The OIG, as it pertains to overall enforcement, they're really now the leading healthcare law enforcer. And this you can see in any of the compendiums that they produce, as well as report to Congress, tying in with their Medicare task force, their HEAT task force, as by way of example, where they're coordinating with other state and federal law enforcement, even local law enforcement, including things like DEA and other departments, where they're all working in sync to try to take down opioid abusers, pain pill mills. There was one that just came out about 10 minutes before our session this morning about in Kentucky, a big takedown that they're allegedly going after. So these are areas, just to let you know, that the OIG, beyond providing guidance and maybe being a pain in your neck, they really are a top law enforcer as far as the government is concerned. Now, they have the authority to conduct audits, investigations, and enforce civil fines and penalties, both criminal and civil. We're going to show you cases where that is the case monetarily, and or CEOs of certain organizations have been personally held liable. So things that I know are top of mind for you. For those of you who are under a corporate integrity agreement, you will find enhanced requirements that you have to both certify to as a compliance officer are being met, and your C-suite now has to sign off on. So the OIG, is making it more difficult for companies to get away with fraud without some type of penalty. Now, if you ask Daniel Levinson, he has said and I think rightfully so. The purpose of enforcement and the way that he views his role as provided to him by Congress is to protect the integrity of the program dollars and beneficiaries. At the end of the day, that's what they're trying to do. Monies have been taken by us in our taxes, allocated to go to CMS, and for Medicare, the federal government is in charge of making sure that it's not fraudulent, and for Medicaid, of course, doled down to the state Medicaid agencies and the Medicaid fraud control units to review. So what has been given to the OIG to help them? Well, a lot of state-of-the-art tools and technology. A lot of the cases that you take a look at lately, it's very apparent. They make it known that they've used data analytics. They've gone in and looked at the claims review materials that you submitted in order to get reimbursed. And then they've done data analytics on them to come back and ask questions or to go after organizations for abusing. So they're getting smarter, and they've now hired a chief data technologist that Don and I actually had a chance to meet, a fascinating woman who actually is focused nothing but on bringing the best practice of data analytics. So they have a robust hotline. We're going to talk in a minute about what was reported to them. And I think what's important about the hotline is you ought to have one. And if your people don't know it exists or feel comfortable going to it, they're going to go to the OIG instead. And I think you'd rather know it before they do. So let's see how that's working in a second. And we talked about Medicaid fraud control units coordinating with the OIG and DOJ for prosecution at the state level. And of course, we're going to go over the civil monetary fines and penalties. So let's look at the OIG hotline. You'd like to think this was zero, because all of it should have been reported likely to the company, but they weren't. Some people chose to go directly to the OIG and not try to bring it to the attention of their employer or previous employer for whatever reason. The OIG hotline activity recoveries from April of last year to September, which would be the latest statistics produced by the OIG to Congress, are pretty telling. Almost 60,000 contacts to their TIPS hotline, 13,000 of which they evaluated, referred to action 10,000 of those 13,000, so a majority for sure. And then as you see how they came in, either by phone or website. So the OIG hotline is for real, and again, I think you'd rather have it come to your organization so you can proactively deal with it. And that might be a takeaway to go back and make sure that your staff is aware it exists, and that that's the way you would like to be able to handle potential allegations. As the OIG's authority specifically applies to exclusions, and of course that's the business that we're in, we want to spend a little bit more time in a minute going through some statistics, but they do have the authority by statute in both section 1128 and 1156 of the federal code. And we'll talk a little about that in a second. There are links here, hypertext links, to take you to their statutory authority if you are new to this or want a refresher. And we spend quite a bit of time each quarter going over how to analyze that. We call it CHIRP, which is our Comprehensive Healthcare Index Report by Provider Trust. And in it, which there's a link there, and I would hope that you'll subscribe, it's free. It analyzes a breakdown of the federal lists, the state lists, how records are not making their way between state up to federal, and you can look specifically in states that you're practicing in or across the board. The key, I think, that's the highlight here is that third bullet point. There are now over 200,000 combined federal and state excluded providers. Some are mutually exclusive. They're only existing at the federal or the state, and some are at both. But over 200,000 excluded providers. And an excluded provider, for a refresher, includes an individual or a company, third-party entity. So the OIG sure was busy in 2017. Donna, you want to talk a little bit about what we found out in looking at that in more detail?
You bet. Thanks, Mike. And before we get into how busy the OIG was in 2017, Matt failed to share something with all of you during the introductions earlier on, and that is that today is Mike Rosen's birthday. So I'm sure all of you would like to wish Mike a very happy birthday and thank him for spending his birthday with us on this webinar. So happy birthday, Mike.
Thanks, Donna, but
So
we're
let's
not
talk
doing
about-
a poll to be to guess on how old I am, so let's leave it at that.
Yes, we are definitely not going to do that because Mike and I are very close in age, so we're not going to talk about that. So, all right, let's talk about the OIG though. So we talk about how busy, or we're going to talk about how busy they have been in 2017. But I think before we get started, let's just take a second and just remind ourselves how valuable the OIG can be in as far as sharing information and knowledge with us in the compliance profession. They certainly, we know, have the OIG work plan. It used to be done annually. All of us used to, I guess, look forward to the new work plan usually in October. Now they've changed that to monthly. So certainly make sure that on your to-do list that you're monitoring for those monthly updates so that you can see what new information came out and how it relates to your particular industry and whether there's anything that you need to update. So that second bullet kind of follows along with that, right? So make sure that your compliance plan is in line with the OIG plan. Now that it's being updated more frequently, you probably want to be doing that same thing. So we also want to remind ourselves of all the special bulletins that the OIG produces. In particular, there's one that's from May of 2013. That's a special bulletin related to exclusions. It's one that we at Provider Trust certainly refer to very frequently. It helps us just really understand, you know, what the vendors are, who the vendors are, how we should monitor vendors, how do we consider, you know, staffing agencies and those people coming into our organizations or volunteers. It just kind of goes through all of the exclusion in a really good, easy to understand way. Certainly, they tell us how they're going to decide whether there's exclusions, you know, and whether it's a permissive or a mandatory exclusion. Now, in these slides that Matt shared with you earlier that we're going to send out to you, anything that's underlined in blue is a hyperlink. So when you get this, it'll take you right to those particular bulletins that we're talking about. Also, corporate integrity agreements. Those documents, I kind of consider them the roadmap or the perspective of what the OIG is now considering almost required elements of a good compliance program. So reading the latest and greatest, especially ones that relate to your industry, I think are kind of insightful into looking at things that we maybe haven't thought of yet for our own compliance program. And then the last one is something that was introduced last year at the annual conference for HCCA, and that's the newest measuring compliance, that program effectiveness guide that was put together earlier last year and introduced in, I think it was March of 2017. So all of those are great resources that the OIG provides us to really help us understand and learn more about our own compliance programs. So Matt, let's go on to the next slide. So here we have another quick little question for all of you. So how many, whoops, don't give away that answer, Matt. How many billions of fraud and abuse monies did the OIG identify through audits and investigations in 2017? And Mike actually kind of did give you a hint in one of his earlier slides, and we'll tell you the real answer in the next slide. So your options are, was it 1 billion, 2.4 billion, 4.7 billion, or 6.4 billion? And I'm sure Matt is going to give us another couple of seconds. He'll tell us when we're going to close it.
Just a few more. We'll let majority of people vote real quick. And okay.
All right. So the winner is 4.7 billion. 59% of you had the right answer. Great job. All right. So let's go on and talk a little bit more about the report that Mike had referred to earlier. So the OIG comes out with their reports, and it gives you some statistics and some information. I kind of find this information, I like stats, so I just kind of like to look at it. But I also think that in compliance, we're always trying to get people to understand why the things that we do are so important. And some of these statistics are helpful when you're having conversations with your senior leadership team, your board. So I always find this document to be helpful. So some of the things that we wanted to highlight are, first, the 4.7 billion, right? So in 2017, the OIG has told us that they have $4.7 billion that they've attributed to fraud and abuse that they've identified from their audits and investigations. That is just a big number in my mind. There were 881 criminal actions taken against individuals and or entities, 826 civil actions, and then there were not a handful, we're going to show in the next slide, thousands of other administrative actions that related to self-disclosures. And then in 2017, or I should say, let's make sure we're always talking about the fiscal year of 2017, right? Not the calendar year, but the government's fiscal year ends September 30th. So in that time frame, they also excluded over 3,200 individuals and entities. So the next slide is a graph that is somewhat duplicative of the previous information, but I wanted to show you kind of the steady incline. I thought it was interesting. So as you look from 2013 to 2017, the civil actions have steadily inclined and almost doubled, not quite, but almost doubled in that 5-year span. And now you look at the criminal actions, it's pretty flat and even just declining slightly. Now, I'm not here to tell you what that means, but I feel like, and I think what we hear often from whether it's Daniel Levinson or other OIG commentary is that, you know, they're looking for us to self-disclose so that we can have administrative sanctions or civil actions not having to go to the criminal level. So I'm hoping that perhaps this is indicative of that message. So in addition to these numbers here, there were also 3,400, give or take, administrative sanctions. Those might have been exclusions or other administrative things that took place. But I just thought it was kind of a nice graphic to show the difference between the criminal and the civil. And this next slide, I just wanted to throw in, Mike talked about the importance of the hotline. The OIG certainly really utilizes, of course, the hotline and the information that they get. I think it was at the enforcement conference in the fall when Mike and I were there. They said that 93% of the OIG settlements were based on KETAM or whistleblower actions. That to me was just crazy. But we all know that the favorite interviewees of the OIG are our former employees, right? So the fact that this volume is here shouldn't be a surprise to any of us, but I do think it reminds us how important it is to make sure that our internal compliance programs really have the culture of come to us, report things, show us, because if we're not satisfying our employees in that fashion, we know that the OIG is happy to give them a call. So this is a case that I am sure we have all read about. It's the biggest one yet, right? The OIG, this past July, we know there is a huge focus on opioid abuse. And in July, there was a combination of every different government agency, right, working together, and they brought down, using like I know anything about it, but FBI terms, I guess, 400 defendants in 41 different federal districts. It accounted for $1.3 billion in false billings related to these different opioid issues. They brought charges now against 120 individuals, and 27 of those were physicians. And I think what's also interesting is they've already issued almost 300 exclusion notices to a variety of different healthcare providers. So you think about that. In my mind, I always think about the exclusion process taking so long, and this whole investigation usually taking a long time. But clearly, if from July to now, they've already issued almost 300 exclusion notices, we know the government and the OIG were working on this long before we ever knew about it, and we're quick to be able to exclude these providers that they had identified.
Donna, so let me just add too, last year in 2017, there were 3,200 roughly added exclusions. So this one case is almost an additional 10% to that number taken in all of last year. So this is a big deal. Absolutely,
great point. All right, Lau, let's just talk a little bit about some specific finds and some statistics. Ooh, easy for me to say. These are three just very different examples. So the first one is eClinical Works. Now, this is the first of its kind. This is the first electronic health record company that has been sanctioned for submitting false claims. So what they did is they actually hard-coded in their software some particular requirements that were needed in order to meet the meaningful use requirement, and then were certified, when in all actuality, their software wasn't capable of meeting all the certification requirements. And so therefore, they were fined $155 million. So those penalties were paid in combination between three of their executives, and the organization were penalized as a whole. So that's the first one we've ever seen of that particular type of false claim. The second one is a situation where the CEO was actually convicted of 98 counts of embezzlement, sentenced to 10 years in prison, had to pay back $13.5 million in restitution, and he and 9 of his companies have been disbarred for 10 years. Now, one would say that if he's in jail for 18 years, he probably is not going to be doing anything for much longer than 10 years. But this is an example of a message that we've been hearing, I think, loud and clear, which is they're not just going after organizations. They're certainly looking at the top of the organization to identify if there were any specific bad actors beyond just an organization that had some bad practices. The next one is a situation where an organization was penalized, or paid, I should say, $2.8 million for submitting services for home health services when the patients weren't receiving those services, or it was improperly coded. So you can see 3 very different scenarios, and I think it shows the diversity that we're seeing in the cases that the OIG is penalizing and sanctioning. So the next slide is just kind of a quickie slide, if you will, to remind us that it's not just the federal, it's not just the OIG at the federal level, but our friends at the state level, the Medicaid fraud and control units, are very connected. And oftentimes the actions that we're seeing are initiated at the state level and then brought to the federal level, or maybe at the state level, they're identifying, Medicaid fraud, but then the OIG, if it's a big enough case, is certainly going to look to identify Medicare fraud as well. So we all know about the Medicare strike forces. There's been over 3,500 defendants and over $12 billion recouped by those strike forces in combination with our the Medicaid fraud and control units. So there's 49 Medicaid fraud and control units across the country that we all need to be monitoring as well.
Here's a little trivia for you. You're probably wondering why there aren't 50. And I believe I read once where North and South Dakota share one. So that's the reason.
Well, see, I didn't even know that. Mike is always good with great trivia. And I think this last one that we just want to highlight specifically to the Medicaid fraud and control unit is a situation that came up at the end of last year, and it had to do with a state employee. So if you're familiar with the post-acute, with the skilled nursing environment, you know that in the skilled nursing facilities, they have what are called surveys. Every year, the surveyors come into their facilities, they identify whether or not there's any deficiencies related to the practices. Then they have opportunities to correct, and if things aren't corrected, certainly there's potential fines and sanctions. So knowing, and these visits are unscheduled, right? You don't know when the state is coming into your facility. So in this situation, one of the state employees was bribed. She was accepting bribes to tell owners when the surveyors were coming into their facilities, so that if it was a complaint visit, that it was a particular situation, she would tell them what the complaints were about, so that allegedly they could quote, fix things or be prepared, more prepared for those surveyors coming into their facility. So for her actions, she was sentenced to 57 months in prison And it's just one of those situations that we really don't hear too much about, but I thought a very interesting case, and one that we could share today relative to what activities the Medicaid fraud and control units are taking. So one more quick question, and I think we're going to turn it over to Mike. So before Mike starts giving us some additional kind of history lessons, if you will, what are the two types of OIG exclusion authorities? Is it mandatory and permissive? Is it mandatory and optional? Is it permissive and required? Or is it required and optional? Take a guess. Hopefully you're not guessing, but let us know what you think. Matt will give us another couple seconds, and then he'll tell us when we're ready.
All right, very good. So results show 69%. So that is correct. Mandatory and permissive are the technical terms that the OIG by statute has. And we're going to talk a little bit about what is one versus another and sort of how it works. So mandatory is by statute, and there are basically 4 types categorically for which an exclusion that the OIG is by statute required to exclude the person. Now, this could be an action taken directly by the OIG, or it could be a case started at a Medicaid fraud control unit that gets reported to the OIG, and then therefore by statute they are required to do so. Basically, it is felonies that are for these types of fraud or patient abuse. So Medicare, Medicaid fraud, which would include any of the other related funded programs, felony conviction or guilty plea, if you have a situation where an individual or entity has been involved with patient abuse or neglect, a felony conviction for any type of fraud, theft, or financial, including tax fraud, those kinds of things, and then felony convictions for unlawful manufacture, distribution, etc. of drugs. Those, the OIG has no choice by statute. If they take action or it's reported to them, they must exclude the individual or the entity. Now, on the flip side, there is permissive. And the permissive, by its term, means they have discretion to do so. And the discretion is granted to them. They did issue some guidance. I think we gave it to you in one of the earlier slides, a link that talked about what are the factors they take into consideration when granting permissive exclusions. The ones that we want to highlight for you, though, it would be a misdemeanor conviction or guilty plea for the things we talked about above in the mandatory section, or the ones here, bullet point 4, suspension, revocation, or surrender of a license at a state licensing board can be, and is one of the main reasons actually that they do issue permissive, as well as the second to last one, defaulting on our federal student loan, of which there are now almost 2,000 exclusions for that. And that is an ever-changing one, obviously, for groups or individuals that fall in and out of default. Now, an action has to be taken. The simple fact that you're in default doesn't automatically create it, but if as a result of defaulting on a federal student loan and that gets reported up, there is permissive authority, and I can tell you that almost in every case they do add you there. It was a really interesting case about a year and a half ago that Donna and I found, where kind of a sad situation, a mother-daughter situation. The daughter went to nursing school. The mother guaranteed the loan. The daughter didn't pay the student loan, defaulted, and didn't tell her mom, and the OIG excluded both. The mother for being the guarantor and the daughter for being in default. So they're pretty serious about this. The last one we're going to talk about in a second, it's kind of a newer one that the OIG is really concentrating on lately, and that's where a individual that is excluded has a controlling interest or management function, or even an officer of a company. So Donna herself gets excluded. What does she do? She opens up a pharmacy under an Inc., but it's really her, and she's working there, or she's doing the billing, or she's simply an officer. That in and of itself is a problem, and the OIG is trying to go after those abusers for trying to hide behind what's called the corporate veil.
Hey, Mike, I think before we move on, we have a pretty relevant question here.
Sure.
Someone asked, do providers have the legal obligation to report employees who committed fraud to the OIG and or state agencies?
Well, that's a great question. Veronica, that comes from Veronica. Do you want to tackle that first, Donna?
Sorry, I was muted. Every organization has to look at the situations that are presented to them. So whether you're reporting it to the OIG, whether you're reporting it to the state agency, each situation is going to dictate where and to whom you have to report. If it's a licensure issue, depending on the scope of practice, you might have to report it to the licensing board. So it's really going to be fact specific, but if you've identified fraud by a specific person, there would definitely be a reporting obligation where you would work with your counsel and determine the most appropriate place to make that reporting.
Yeah, I would agree, and I would add to that. I would go back and check your compliance plan and make sure that you address that, like what happens in certain situations, because clearly if you have in-house counsel, they would be involved, and your job as a compliance officer is to find it and then report it up to the right channels. It would be up to your counsel or outside counsel to determine at what point they're going to self-disclose, they're going to investigate and close out the matter internally, whatever the plan is. I would make sure your plan addresses that, because these things do pop up, and as they are fact specific, your plan should address at least where the report should go once your department is involved or finds out about it. So, very good question. Okay, on the exclusion sources, we want to make sure that you are reminded and or educated on the ones that are out there. Of course, the OIG can only require you to search their own list, the LEIE, list of excluded individuals and entities. And they do. They have guidance that says you should be checking this on a monthly basis because we're updating it. And the standard of how we hold you liable is what you knew or should have known. Because it's public, you should have known. So submitting a claim on behalf of an excluded individual where you knew or should have known is a problem, and that's where they issue civil monetary penalties for violating that and or can exclude an individual organization. So the LEIE, as of the end of February, has almost 70,000 excluded individual entities. There is a second data set called sam.gov, which for those of you who've been around a while will remember the old Government Services Administration Excluded Party List, EPLS. That has now no longer been updated and has merged into a broader database called sam.gov, which has debarments and exclusions. And these are individuals or companies that have defrauded the federal government under a GSA contract, or they have defaulted under their contract. And it is supposed to also include all of the OIG LEIE. I would not rely on SAM to do your OIG screening because they're two different data sets, even though they claim that they're supposed to have all of the LEIE. You need to check the LEIE separately as the primary source. But best practice would include adding SAM, and although there are way more than 68,000 debarments and exclusions within SAM, the 68 represents those related to healthcare. So there are other things involving EPA, involving Department of Defense and other federal agencies. But if you call those out, there are almost exactly the same number in SAM that are healthcare related as there are in the OIG. Lastly, there are 41 state Medicaid exclusion lists. And that number increased this year by an additional 1 to 41. And there are almost 63,000 individuals and entities on those combined lists. We're going to talk in a minute about which states have the most ones. And your question is going to be, should I search, or am I required to search all of them, or just the ones in which we're doing business in that state, or what do I do? And our best practice advice, not legal, but best practice advice to you, and what we include in all of our screenings is a search of all three of these lists. If they exist and they're out there, we feel like you should know them, and then make a decision whether or not they are relevant. Clearly, an OIG is very relevant in all cases. SAM should be a repeat of the OIG. It's usually from the same list, but could be something different. And then you need to look at what state you're doing business in. That provider or biller that you're going to bill for is doing business in, especially if they're like a traveling nurse or doing business in multi-states under a Nurse Compact Act. Clearly, knowing that an individual is excluded by the state means you cannot bill that state Medicaid. The question is, what happens if they're in a state far away or unrelated and it preceded them coming to you? I'm not going to give you legal advice there, but we're going to include that in our report so you can make an informed decision. The last point there is that if you believe that all of the state list exclusions reside within the OIG, you are sadly mistaken. Our CHIRP report goes through that in detail. The statistics that come directly from the OIG themselves, CMS, when they audited OIG's report back in 2008, which is the most current statistic from them, they found that the OIG was missing up to 2/3 of what exists at the state. So it is a Swiss cheese database from the standpoint of, unless a state Medicaid fraud control unit tells the OIG they took action, the OIG will not know, should not know, and really has no reason to know. So it's dependent upon how good the state Medicaid fraud control units are in reporting out. We blogged on this quite a bit, and every time a state review is issued, we publish it so you can look to see how your state is doing on our blogs. A exclusion has a couple of things that are pretty standard across the board. They're typically for a minimum of at least 5 years. We have seen some that are 2 and 3, but by statute, really, that's an exception, and where they have granted a lesser term. By statute, it's 5 years or more. They can be permanent. We're going to show you an example in a minute of one that is. You need to know bullet point number 2. In the event an individual or an entity has been excluded, certainly at the OIG, but also at the state, it is incumbent upon them, the excluded person, not you, their employer, to seek reinstatement. You cannot apply on their behalf, and they are the only people who can. They're only allowed to apply for reinstatement upon the end of their term. So if it was a 5-year term and they have met the qualifications after the 5 years, they have to affirmatively apply. If they do not, which we see all the time, and it's now 10 years later, and in their mind, they say, well, I met my 5-year term, I don't have to do anything, they're wrong. And you will be fined if you bring them into your fold. So a exclusion that has a previous date that has passed, given the current year, 2018, but is still active, is your problem, your fine. So the individual must apply for reinstatement. What are the fines? So by statute, the OIG can fine up to $10,000 for each item claimed, not reimbursed, but claimed. Simply putting it on a claim statement is all it takes, plus 3 times the total amount for what is called treble damages, unless you self-disclose that exclusion to the OIG, and then they'll simply reduce the 3-time damages to 1.5. You'll still pay. If it is an individual that you do not bill for separately or cannot be broken out in a claims form, then they'll take your salary and benefits for that individual during the term in which they were excluded, and they'll multiply that by 3 if they come to you, or if you go to them, they'll reduce it to 1.5. So that's how they do it. And when Don and I calculated last year's exclusion-related civil monetary penalty fines that were self-disclosed. So these are the ones that they would have been 3 times, but they only got a 1.5 multiplier by self-disclosing. The average was $129,233 per person. That means it really was $230,000 if they had not self-disclosed, and that is an average. Some are a lot higher, some are less. Thought that would be of interest to you as to how this adds up. As we round out the exclusion area, we think stats are important. That's what we focus our business on. Did you know that 90% of exclusions at both the state and federal data sets are based on people? but people can be owners or officers of corporations, and that's an additional exclusion that the OIG is issuing. The three most common names, two of which are singers, unless Robert Williams is also an unknown singer. But James Brown and James Taylor, 1 and 2, Robert Williams, number 3. Other names that you see which are either ethnically related, a Maria Garcia, those types of things will generate tons and tons, as these will, of possible records that somebody has to go through and determine if there is a match. On the OIG site, the Social Security number will do that for you once you enter it. On other state lists, it is glaringly missing, and it is much more difficult to find a common name to delineate that it is or isn't yours. Sometimes it's only an address. As I mentioned earlier, a permissive exclusion is defaulting on a federal student loan. There are over 2,100 cases of that currently. The 5 states, probably not a surprise, that have the most excluded individuals: the wonderful left state of California, the great state of Texas, where I went to college and met my wife, New York, Pennsylvania, and New Jersey, rounding out the East Coast corridor. These are the states that have the most individuals that are excluded. Top 5 job titles, thought you might want to find out those. These are the ones for which hit the OIG and state lists the most. No surprise, nurses, owners, operators, and doctors. But nurse aides, obviously, a large number there too. This does not mean that if you are not licensed, you cannot be excluded. These are just simply the top ones. And the reason for that is that when you look at the OIG, 48% of exclusions in the OIG stem from a license revocation, almost half. So over 30,000 of the 68,000 have had a license, and that's how the OIG found out about it. I mentioned to you before, and I want to highlight to you that individuals that are controlling or managing an entity, it's in their special guidance. There's 1,500 excluded people who are also owning companies. So it's a real issue that you need to be faced with. As we round out today and get through from the purpose of time, I'm not going to go through the rest of the exclusions, but it does statistics, but it on average takes almost a half a year to get from a state Medicaid fraud control unit to the OIG. So knowing that in advance is important. And some more information on ways you can search with just like an NPI number are out there. Let's go over a few of the cases of enforcement and stay within your time frame of the next 9 minutes. So here are a couple of cases, and we're not casting any aspersion on any of these companies. Genesis, there are allegations made, currently being fought vigorously by Genesis, that resulted in them agreeing to a settlement agreement, but not agreeing to liability. They'd rather resolve the matter than fight it. That doesn't mean that they believe that this happened. But Genesis, a skilled nursing and senior living dominant player, settled and paid over $52 million to resolve alleged FCA liability. In New York, David Mirzoyan, if I pronounced that correct, was part of a criminal enterprise. Criminal organizations are getting into Medicare fraud big time. And what they're doing is they're doing pop-up doctor's offices that are there for 90 days. There's actually nothing behind the storefront at all. And they're typically getting referrals on top of it from doctors and paying for those. And they're raking up millions of dollars. They closed down the, quote, shop, meaning there was really never one there. And they've collected millions, and they're gone on to a new city. This is netted to this group, this particular group, over a 17-year sentence in jail, in prison, $20 million in restitution and forfeiture. So in addition, you can see that the scheme was combined 51 years of fraud there, fraudulent billings. Lastly, in California, this is to show you that they're not going after just the big boys, the Genesis of the world or the criminal organizations. This is a small medical center that resolved allegations in illegal referrals and referring physicians and below market rate, paid $42 million. That could bankrupt most small companies. They're also under a 5-year CIA. Now these last cases here, we're not going to have time to go through, but want to highlight both the dollar amount and the variety. They have everything to do with nursing homes to case management providers paying large fines for the company hiring an excluded person and then billing CMS or services for it. The third case was a diagnostic lab, a sleep lab, which if you look at the work plan, they're going after that industry pretty heavily in 2018. And then the pharmacy is no surprise. Pharmacists can rack up very quickly. Here's a almost $350,000 fine for doing so. And then the bottom case is a permanent exclusion. So this was so bad that the OIG said, you're out. You cannot ever enter or re-enter the billing privilege program with Medicare and Medicaid. Lastly, I want to, on slide 39, show you some really, really severe cases, but tells you the furthest extent the OIG can go. Robert Brookheim in New Jersey assumed the identity of a dentist who ultimately died, and he, after that dentist's death, that he assumed the identity of, still continued to bill Medicare and Medicaid. Mr. Brookheim, who I don't even think is a dentist, paid over $1 million in fines and is excluded. Terry Diamond, 8 years by providing unlicensed services without supervision. A whole nother issue that ties into why license tracking and management and monitoring is important, but can subject you to fines or exclusions also. Dr. Yoon, we see too many of these, physician excluded for providing services in which he wasn't even enrolled in Medicare, yet he was billing Medicare. It should never happen. They should have never paid it, but they did, and they've excluded Dr. Yoon. And lastly, Dr. Patel, a 5-year exclusion, but he continued to provide administrative and management services by transferring ownership to his wife. That's what we were highlighting before, the 1,500. He's one of the 1,500 excluded individuals, but thinks he can get away with hiding behind the corporate veil this way, trying to hide it under his wife's name, but having a management involvement is enough to get you in trouble. For those of you who would like to follow the cases that you typically see on Dateline, Thurley and Royley Belfry are quite the pair. These two brothers abused for over 15 years, blatantly, involving their accountant, who was also the former mayor, who filed false tax returns. These clowns were big time into fraud, and then getting houseboats and cruises and all kinds of lavish trips, and the government slapped them big time. That's one that's kind of fun to read if you want to see how people think they can get away with murder there, basically. So these are cases that we wanted to just highlight to show you the extent and breadth. Donna, as we wrap up, if you can kind of give people ways to avoid and plan better to avoid these types of things.
You bet. Thanks, Mike. So just kind of in conclusion, just a few thoughts really, like Mike said, of the things that we can do to make sure that we're not on any of those lists that Mike just shared. So certainly, as we're looking at a new year in 2018, really just looking at our own risk assessments, what we're doing, what we're monitoring, what are our areas of concern, and do we have stopgap measures or mitigation plans in place for the areas that we already know that we may have some opportunities to improve. We talked a lot earlier on about the importance of your hotline. So certainly looking at your metrics, you know, we used to monitor the centers or the locations that didn't have any hotline calls. And so not only the current volumes, but if you're not getting any calls for a particular location, you know, doing a little bit more of a deep dive as to why. Certainly monitoring your own individuals, your own employees, those entities or vendors that you're working with, making sure that you have routine monitoring in place so that you don't get caught off guard. Mike kind of went over just briefly the importance of monitoring licenses as well. We know that about 45% of the OIG exclusions relate to license revocation issues. So if you're monitoring your licenses or your provider licenses routinely, you're going to know if there's a disciplinary action or a sanction against that license before you ever have to worry about it becoming an exclusion situation. Certainly always looking at your compliance plan, right? Making sure that you're updating and continuing to be current with any new guidance, anything that comes out from the OIG. We talked about looking at corporate integrity agreements, kind of the latest perspective of what the OIG is considering best practices in a compliance program or things that we all should be doing. And then the last one we've not really talked about, but certainly the OIG continues to come out with training videos. Some of them are unique to certain industries. Others of their videos are just kind of compliance 101. They are there for all of us to use as a resource. And certainly you could consider embedding some of those training videos right into your program. So then it's not only that your team is hearing the right message, but they're also hearing it from the horse's mouth, if you will. So those are just a couple of quick tips. I know it is 12:56. We usually try to end early. Mike and Matt, I don't know if there's questions that we want to cover today. Otherwise, that's it from me.
Yeah, thanks, Donna. So we do have a few minutes left. If anybody does have a question, we're happy to answer. We'll be on the call here until 1. But we do want to just cover a few more things. We will be sure to share our recording as well as the slides and a link to our resource page, which has a lot of helpful ebooks, Chirp, which Mike talked about earlier, a lot of information on the industry and stats that are helpful and surprising. And so we'll share all that with you, as well as an opportunity to check out our blog, which we are proud of and post very regularly about a lot of relevant topics. And we'll also be sure to invite you to webinars in the future. We are so glad that you guys take the time out of your day to join us, and hope you find this information helpful. If you think we could make it better in any way, please let me know, and we'll work to do that. But other than that, I just want to say thanks from us. Mike and Donna, thanks so much, and hope you all have a great rest of the day. If you do have questions, we haven't gotten any yet, but please don't hesitate to send them my way, and we'll get back to you as soon as possible. So thanks, everybody. Have a great rest of the day.